welcome to today's CLE program, Arkansas Eviction Courts, creating a sustainable access to counsel eviction court program in Arkansas. Thank you once again for joining us and taking the time to be here today. We're delighted to have you with us. I'm Haley Ortega, and I serve as a pro bono coordinator for Legal Aid of Arkansas, and I'll be your moderator for today's program. We're also joined by our pro bono director, Casey Copeland, who will be offering closing remarks at the conclusion of today's presentation. And before we begin, we've got just a few housekeeping items to cover. Today's session will be recorded, and then following the program, you'll receive a certificate of attendance, an evaluation form, and you'll also be provided with today's presentation materials. For questions, please use the chat box, and we will reserve some time at the end to address as many as possible. And with that, we will move forward with introducing today's presenter. Zoya Miller is the Assistant Housing Workgroup Leader and Staff Attorney at Legal Aid of Arkansas. She currently oversees the development and expansion of Legal Aid's Eviction Court Access to Counsel program in Pulaski and Greene counties, and also is spearheading efforts to expand efforts for eviction court access statewide. Zoya, thank you so much for being here today, and I'll go ahead and turn it over to you.
Thank you so much for that introduction, Haleen. And thanks everybody for taking time today to be here, for taking your lunch break to be here to talk about eviction courts in Arkansas. So just to give you background into what eviction courts are. In January of 2025, Legal Aid of Arkansas got a HUD grant to help us focus on eviction prevention and defense work. And so in the past year, we've been piloting an access to counsel eviction court in Pulaski County under this grant. And so today, what my focus will be on is going into a bit of the current state of Arkansas landlord-tenant law, just to give you an idea of what that looks like right now. I'll cover the impact of evictions and housing instability on families in Arkansas. And then we'll talk a little bit just generally about tenant right to counsel programs and the outcomes of our 1-year eviction court pilot here in Pulaski County. So let's go ahead and get started. Okay. So let's start with an Arkansas eviction law overview. If you don't know anything about eviction law yet, I can tell you that Arkansas eviction law has several unique characteristics that distinguish it from other eviction laws in nearly every other state. Generally, there are limited statutory protections for tenants in Arkansas, and that makes the eviction system here particularly difficult for tenants to navigate. And my primary job, I do eviction defense primarily. So all day I'm working with tenants who are facing eviction, and I'm hearing about their situations and the cascade of effects that evictions can have on them. And so I'm fairly familiar with the system right now, and it definitely can be distinguished from other states. So I'm going to break it down part by part for you. So there are 3 mechanisms to evict a tenant in Arkansas, but the most common is the unlawful detainer process, and that's under Arkansas Code Annotated 1860-301. So landlords have to go through one of these processes. Unlawful detainer is the most common. And just a side note, self-help evictions unlawful in Arkansas. They have to go through these court processes. Most evictions are based on non-payment of rent. And so in non-payment of rent cases, landlords under the unlawful detainer process right here in the middle, they have to give a 3-day notice to vacate for non-payment of rent. And if the tenant does not vacate within 3 days, then they can go to court, file that unlawful detainer action in circuit court, and then they have to serve the tenant with a summons and then a notice of intention to issue a writ of possession. The tenant then has 30 days to file an answer, but they only have 5 days, and that excludes Sundays and holidays, but only 5 days to file an objection to the issuance of the writ of possession. This is a major point of confusion for a lot of tenants who are facing eviction. I'm just going to pop over to the other slide real quick. The summons for an unlawful detainer is fundamentally confusing for tenants. So ACA 1860-307A, it states that the customary summons shall be served on a defendant and that the plaintiff shall also issue a notice of intention to issue a writ of possession in the format set out by the legislature. So you have this first page right here. This page states that the tenant has 30 days to file an answer. A lot of the time, what we see when we get tenants calling in for help is that they thought they had 30 days to file an answer to contest possession. But this is to contest a full the damages, so the rent. The eviction process is bifurcated into possession hearings and then damages hearings. There are two separate hearings with two separate purposes. The next page, if you flip to it, it's behind the first page that says they have 30 days to answer. It's the notice of intention to issue a writ of possession. There's usually a block of text right here. It's difficult to understand, but in the middle of it, it states that the tenant has 5 days to object to the issuance of a writ of possession. The distinction between the 30-day notice to answer and the 5-day period to object is lost on many tenants. And if I didn't have an understanding of the law because I work evictions, it would be lost on me too. I know if I would receive service and it's laid out like this, I'd be very confused as to what my obligations are too. So because of that, we regularly get calls from tenants who relied on the 30-day deadline when they should have submitted an objection in 5 days in order to preserve their housing and have a hearing set. So this procedural confusion contributes to a significant number of default judgments for possession across the entire state. So going back to the other mechanisms for eviction in Arkansas. So there's another civil eviction procedure, and that's under the Arkansas Residential Landlord-Tenant Act of 2007. And so unlike unlawful detainer actions, there's an implied notice under this statute. So non-payment of rent it acts as an implication that a lawsuit will be filed against them. So no notice requirement like the unlawful detainer statute. And then the process, the complaint is supposed to be filed in district court. And that's, so we tend to contest that because eviction actions traditionally fall within the jurisdiction of circuit courts. And so the statutory process laid out in the Arkansas Residential Landlord-Tenant Act, it can present jurisdictional issues, but we don't see this act used very often. We see it a lot in like the Van Buren, Fort Smith area, but we often raise jurisdictional issues when we see a case filed under the Arkansas Residential Landlord-Tenant Act. And then over here on your left, there's the failure to vacate statute. And this is a criminal eviction statute. That's 1816-101. Arkansas is the only state in the nation that criminalizes non-payment of rent through its failure to vacate statute. So under this law, a tenant who fails to vacate after receiving a 10-day notice can be charged with a misdemeanor and then fined up to $25 per day after the expiration of the notice period. It says up to 25, but what I usually see is that they get fined the full 25. So if they stay past 10 days, they can't find somewhere to go. It's 25, 25, 25, 25, 25, and it just accumulates when they already owe rent. So it poses difficulties for tenants who are trying to move out. Prior to 2017, the statute also permitted incarceration, but that was amended by the Arkansas legislature. So the possibility of jail as a penalty under the failure to vacate statute has been eliminated. But a lot of the time, what we see in practice is that tenants will fail to appear to court on the failure to vacate charge, and then there will be an arrest warrant issued for failure to appear. So we see tenants arrested under the statute, well, not under the statute, but because they failed to appear to court. We have also in practice encountered situations where tenants are threatened with arrest under the statute, even though there's no legal basis for the arrest. It's inconsistent with the statute, but we have seen this happen. We try to address it when we do see it happen, because it shouldn't be happening under this statute. The criminal eviction statute, it doesn't give landlords a mechanism to physically remove a tenant from the property, but just as a practical effect, it's intended to pressure tenants into removing themselves from the property to avoid a criminal charge on their record. And so often tenants will remove themselves. But if a tenant does not leave, even though they've been charged with failure to vacate, they're accumulating $25 in fines every single day after 10 days. If they're still not leaving the property, then the landlord will still have to file a civil unlawful detainer action to physically get the writ that authorizes their removal from the property. Another note on the failure to vacate statute, its enforcement varies drastically across the state of Arkansas. So there are several circuit courts, several counties that have held that the statute's unconstitutional. And so Pulaski, Craighead, Poinsett, and Woodruff have. And then there are some prosecuting attorneys who decline to prosecute these cases altogether. And then on the other hand, there are some counties that use this as one of the most heavily relied on mechanisms for eviction in their county. So we see the most in Garland County and in Miller County, and then scattered around through southern Arkansas. And so a tenant's experience of eviction, because of all of these different mechanisms, because of how the failure to vacate statute is enforced and consistently across the state, as a result of that, a tenant's experience of eviction can differ significantly depending on where they are located in the state. And also as a side note, on top of all of this, Arkansas doesn't recognize an implied warranty of habitability. So landlords don't have to maintain rental housing in a habitable condition. And then Arkansas has no general statutory prohibition against landlord retaliation. And so taken together, all of these laws make Arkansas's landlord-tenant system and evictions unlike that of nearly every other state. Also contributes to a very high eviction rate. Some data from 2022 showed that about 10% of all landlord-tenant relationships in Arkansas ended in eviction proceedings. That's a little bit over 10,000 court-involved eviction cases where evictions are filed. And that rate is considerably higher than the national average. So the national average is around 6.2 to 7.8%. And then here it's about 10%. All right. Just a quick note about subsidized housing and unlawful detainers. There are more protections for tenants who are in subsidized housing because federal law applies. So federal law that governs subsidized housing provides the protections. And this can be public housing, Section 8 vouchers, Section 8 project-based vouchers, multifamily properties, and LIHTC properties. So typically, HUD requires good cause for eviction, except for Section 8 voucher-based housing. They can't evict solely because the lease ended. Notice of termination has to be in writing, and it has to specifically state the reasons for eviction with specificity. And then in public housing, individuals have the opportunity for an informal and formal hearing. In project-based voucher housing, they have an opportunity for an informal hearing before it even goes to court. For Section 8 terminations of the voucher their tenants are entitled to an informal hearing. So more protections for tenants in subsidized housing, because for the most part, Arkansas law doesn't apply here. Dial versus Star City Public Housing Authority is a case here that established the right to an informal hearing in subsidized housing in Arkansas. Okay. So I work in Central Arkansas. That's primarily where I provide eviction defense, but we have attorneys all across the state who handle them. But in Central Arkansas in particular, about half of the evictions filed across the state are centered here. So I'm going to focus for a bit on Central Arkansas. So there is in May of 2026, the Little Rock Board of Directors formally declared that Little Rock's facing a housing crisis. And then that just recognizes what families have been already experiencing for years. Housing is becoming increasingly difficult to find, afford, and maintain because of rising rents and limited supply. And then the housing stock is also aging. So there are several habitability concerns. And this crisis is reflected in the numbers. So I pulled these numbers from Eviction Lab over the last 12 months in the greater Little Rock area. So that's Pulaski, Faulkner, Grant, and Lone Oak, Perry, and Saline counties. And I pulled this data yesterday. So this is as of yesterday. 5,745 evictions have been filed. This is counting evictions that made their way to court. So this doesn't count everyone who's received an eviction notice and left, which is actually the majority. Most people will try to leave very quickly, not wanting an eviction action to be filed against them. So that 5,745 number, that's filings in the greater Little Rock area. And then, like I said earlier, more than half of all eviction filings in Arkansas occur in this region alone, in the central Arkansas area or the greater Little Rock area. Every single one of these eviction filings, it represents a household who's facing the possibility of losing its home and the individuals becoming unsheltered. And in the market as it is right now, affordable housing's already scarce. And an eviction for most people doesn't just mean, oh, I have to move somewhere else. And that's the end of it. I just have to move. That's not usually what we see, and that's not what people experience. So for many families, especially here, there is not another affordable place to go because rent is too high, housing stock is too low. And in subsidized housing, if somebody's being evicted from subsidized housing, you have that eviction on your record, often you'll lose your voucher. If you owe a subsidized complex money, you can't get into other subsidized housing. So that low income subsidized housing is very difficult to get into after somebody's facing an eviction or there's been an eviction action filed against them or a judgment against them. From what we've heard from our community partners too, most of the shelters here are full, like at capacity. The city of Little Rock is putting some efforts into building more shelter space. Have lots of very interesting projects going on right now to expand shelter space, but as of now, most of the shelters are full. And then rental assistance resources are scarce. I know that the CADC, they have been offering some rental assistance, but it runs out very quickly. It's very spotty. And so people get stuck in a cycle if they face financial hardship that leads to an eviction. And so that's what I want to talk about a little bit next. Just the human cost of an eviction. And I think the best way for me to understand, and for others, I think, to understand, has been to look at it from the perspective of as if you were losing your home and how this would impact you. So this is the roof over your head. I've helped hundreds of tenants. I've heard them describe these cascade of harms to me in real time. We speak to a lot of people who have writs issued, calling us and from their car because they've been sleeping in their car, losing their job either before the eviction or as a result of the eviction, facing money judgments, trying to recover one part of their life while the other crises keep piling up on top of them. So I hear a lot of it. I have an on-the-ground view of what an eviction looks like. So I want to take a moment to step into what the cycle looks like for a lot of people that call us. So just imagine you lose your job at the worst possible time, and you were already living paycheck to paycheck, and now you fall behind on rent. Um, in Arkansas, your landlord's not required to work with you. Some will, many won't. So there's a 5-day grace period at the beginning of the month before they can give that 3-day notice to vacate. And so let's say you get a 3-day notice to vacate. 3 days later, after getting that, you still don't have a job. That's not enough time to find a job, not enough time to get enough money to catch up. And you still don't have well, you don't have money for a security deposit to go somewhere else. And so the eviction is filed, and then a cycle can start to begin from this point. And that's what we usually see. This happens to you, you're one of roughly 3 million people in the United States who've had eviction cases filed against them. And so it's also important to know that cycle doesn't affect everyone equally. There are some people who are more susceptible to this cascade of systemic harms. So Black renters, Latinx renters, and women experience eviction and the negative consequences of eviction at disproportionately high rates. So the Eviction Lab found that on average in counties with fewer than 40 Black renters for every 100 white renters, there were nearly 80 eviction filings against Black renters for every 100 against white renters. Women were evicted at rates of about 16% higher than men, and Black and Latinx renters were more likely to face repeated eviction filings at the same address. And then going back to women, in particular, pregnant women face a unique set of risks, and these consequences can happen before their child is even born. So researchers have analyzed more than 88,000 birth records from mothers who have received eviction notices. And the evidence shows that mothers who received an eviction notice during pregnancy were more likely to give birth prematurely and more likely to have babies with low birth weight. And as the cycle continues, the stress compounds, and the uncertainty of losing your home can create chronic anxiety, depression, and emotional distress because you're losing the roof over your head. So one study found that depression generally, about 18% of the general population has depression, but 30%, 31% of renters have depression just being renters. And then among renters who are falling behind on rent, that number increases. And I think one of the most important takeaways from this slide, I would say, is that it's important to think of eviction not just as a financial setback for a family, because having a roof over your head is a basic necessity. And so when you lose it, a lot of people enter into survival mode, and survival mode is not just a feeling. It has measurable health consequences. So there's a national study. It examines millions of eviction cases, tracked them over time, and found that just simply receiving an eviction filing, not a judgment, filing, even if it never resulted in the judgment, was associated with a 19% increase in premature mortality. And then receiving an eviction judgment was associated, and this is the judgment, not just filing. Receiving an eviction judgment was associated with a 40% increase in the risk of death. So once somebody enters this cycle after an eviction is filed, every loss makes the next loss more likely unless there is some sort of meaningful intervention to prevent the cascade of harm. But a lot of the times there is no meaningful intervention for tenants who are facing this type of hardship, especially in under-resourced states, just like Arkansas, which has fewer lawyers per capita than any other state. One reason that these harms cascade like this is because there's a fairly severe representation imbalance in eviction courts. So, and this is across the country, this data. There's representation gap where only about 4% of tenants have legal counsel compared to about 84% of landlords. So when one side almost always has an attorney and the other almost never does, tenants are far less likely to understand their rights or assert the protections that do exist for them, or understand how to take these things to court and navigate the process. In a state like Arkansas, where tenants have relatively few protections, it's the way I like to view it is, even with the few protections that exist, if there's no one there to enforce them, do they really exist? So with that idea, I think having an attorney on the other side is so crucial and so important for tenants who are going through the eviction process, to help them understand what protections that they do have. In Arkansas, well, nationwide actually, 7.6 million Americans face the threat of eviction each year. It's the 3 million number is filing, 7.6 face the threat. And if 96% of them are navigating the process without an attorney, it makes sense why the systemic harms ripple through our communities in the way that they do. But the other side of this is that if you add representation, if you give a tenant representation, this can change outcomes. So multiple studies show that tenants with legal counsel are significantly more likely to remain housed, avoid eviction that doesn't have merit, and if they have to leave, they get to secure time to leave through agreed orders. And having counsel on the other side tends to reduce the lasting, like, financial and health consequences associated with eviction. So, and I was just talking about this a little bit, but access to counsel programs are starting to pop up all over the US. And it's a pretty good solution to the problems tenants face when combating the cascade of systemic harms that come from evictions. So 28 jurisdictions, and this includes cities, counties, and states, they've enacted laws guaranteeing legal representation for eligible tenants facing evictions, because a lot of states are recognizing that eviction proceedings do have life-changing consequences for people, and then access to justice can actually help offset those consequences. Legal Aid right now is working to develop an eviction right to counsel program. We've had it going for a year, a pilot in Pulaski County. I'll talk about that in a few. And our long-term goal is to expand it across more of the state. We've expanded into Greene County to test it in a more rural county, and we want to go further than that. There is a lot of evidence out there to support these right to counsel programs. Studies show that tenants represented by attorneys are 2 to 3 times more likely to remain in their homes. And then even when an eviction cannot be avoided, what attorneys can do is negotiate for additional time for the family to relocate safely that avoids the eviction judgment, or negotiate some sort of repayment plan, things like that. And with representation, a tenant's likelihood of getting a judgment is significantly reduced, which is also very helpful because it's the eviction judgment that prevents tenants from finding other housing. So having that judgment on the record can significantly impede their ability to move to other places. And when housing stock is so limited, and somebody gets an eviction judgment, their barriers to finding housing just increase significantly. So avoiding that judgment benefits people tremendously. And the benefits expand beyond just that to the tenant. Court systems benefit from access to counsel programs. It reduces procedural errors from pro se litigants, facilitates settlements, keep these situations from going to full hearings a lot of the time, and often help cases move more efficiently. And then communities just in general can benefit because by preventing unnecessary evictions, that reduces reliance on shelters and emergency shelters, healthcare systems, foster care, and then just any other public service that tries to remedy housing instability. So I want to talk a little bit about the Pulaski County Eviction Court pilot. So this is what we've been working on for a year now. So we started in August of 2025 with the goal just to pilot to see what works, see what doesn't work, see if it's really benefiting people. And one of my concerns was in the state of Arkansas, where the laws, the tenant protections are so almost non-existent. Will an access to counsel program really be effective? And so that's what we wanted to dig into. So this Pulaski County Eviction Court pilot, it operates in the 12th Division, which is Judge Connors, and the 14th Division, which is Judge Johnson. And then we've worked with court staff to coordinate the scheduling of the hearings. Well, the dates for the hearings. And they're usually set for 2 to 3 days a month, where the court works with us to try to set as many unlawful detainers on the same day as possible, and we come to help those who need it on the day of. It's usually what it requires of us is to have about 2 attorneys present, and then 1 to 2 staff members who can work through intake and interviews. The days are usually like hustling and bustling. It's exciting, honestly. And we handle cases just right then and there. A lot of times we're not able to make contact with the tenants before the day of court. So it's really a shuffle at the beginning to try to get everybody through intake and then handle the case. We handle about it varies widely. It's about 1 to 15 eviction cases per session. 15, like at the top end. We've been able to do it because a lot of cases settle. Sometimes you never know if a tenant will show to their hearing. So when we go, we don't know exactly what to expect, and we just take it as it comes. And like I said, same day intake, legal screening, and defense identification, unless we're able to get in touch with the client before, which we will try. If there is a number available on their answer or objection, we will let them know that we will be present and give them the option to apply. So it's not solicitation, just let them know we will be there. But everyone we have asked, every tenant who's being evicted has accepted representation. So the tenants are wanting representation. And then we try to capture as many through, an early, try to call them early, capture them before the day of the hearing. But most of the cases we intake on the day of their hearing and meet the tenant on the day of their hearing. How we prep, we just put together a case binder for the day with all of the pleadings printed out in it. Our staff members help us put together that. Then we do coordinate who will be there, coordinate with the court staff, bring all of our supplies, get a table set up, and then we handle it on the day of. Handle the hearings. If they go to a hearing, most of the cases settle. And then it's what we provide is it's limited scope representation, so it's not full representation. So we don't take it all the way to a damages hearing. We just represent them for their possession hearing. So on the day of, we enter our appearance along with a notice of intent, notice of limited scope representation. And then after we're done with representation, we submit a notice of completion of limited scope representation. So it's focused only on the possession hearings. That's kind of what it looks like whenever we go to court. We've had some very, very good outcomes that I want to talk about a little bit. So like I said, 1-year pilot period started in August of 2025. We've collected data through August of 2026. We have provided representation to 62 tenants, limited scope representation at these eviction courts. This doesn't count Greene County, and this also doesn't count cases that are still open. Some of our cases remain open as we handle odds and ends. But to analyze outcomes, we took that out of the data, went ahead and analyzed the 62 that have closed. The number that we have represented is somewhere in the 80s right now, but focusing on the 62 that are closed. So 51 cases ended in negotiated settlements, 8 resulted in favorable court decisions for the tenant, and 3 resulted with just a writ being issued without any sort of negotiated agreement. And we consider negotiated settlements as favorable outcomes for the tenant. And so based on this data, in 95.2% of cases, the tenant had a favorable outcome, be it a negotiated settlement or that the writ wasn't issued during the hearing. And even in the 3 cases that did not have a positive outcome, the tenant was still able to benefit from our presence because we have case managers on staff that can help with stabilization services, be it emotional stabilization or helping stabilize their housing situation. And then we were able to provide advice on how to handle their case moving forward. And I think one of the most important things to take from this data is that through this 1-year pilot, the outcome is almost precisely in line with the data from national research on the impact of implementation of eviction access to counsel programs. So the data just nationwide is that 96% of the time, if the tenant has an attorney by their side in the courtroom, they will win or settle. We're right on the mark with that. Without an attorney, tenants win or settle only 62% of the time, and that's a significant difference. And I want to emphasize how important it is for this data to match up with what national data has shown, because access to counsel programs and the data that results from them, well, their outcomes are measurable and reproducible, and importantly, also achievable in Arkansas, which has some of the fewest tenant protections in the country. And I said this before, but one of my original worries was that in a state with very few tenant protections, would a program like this be successful? But turns out that yes, it will be successful, and it will be aligned with national data. And that's the power of having an attorney on the other side too. And I think that's accomplished through a lot of negotiated settlements. 82% of the cases we handled, we were able to reach a settlement before it proceeded to a full possession hearing. And sometimes during the hearing, like we'd be going on in a hearing and then we'd reach a point where we come to the agreement of a settlement during the hearing. So that can happen too. But 82% of these cases were settled. And I think that's great because settlements tend to protect the interests of both parties. And also do even more to increase courtroom efficiency. So in most of the cases we encounter, tenants tell us that their goal is not to stay in the home indefinitely. Most of them, when they get an eviction notice, they want to make that move, but they just need a little bit more time to relocate or time to, get everything together, get family members to help them to actually make that move. It's not easy or cheap to make a move. Some tenants also have the money on hand ready to pay, and they just need the opportunity to pay it, or they need a payment plan. And so the settlements help tenants quite a bit because the issuance of the writ or the eviction judgment, it can significantly impact a tenant's ability to secure housing in the future. So that judgment, that issuance of the writ, say and it's pretty strict in subsidized housing, say if they're trying to now get into subsidized housing, which is cheaper housing, and they go into their record, the housing authority, and sees that a writ was issued. It's at the point the writ is issued that they consider the eviction has occurred. And that prevents them from getting into low income housing. And so we try to prevent the writ from being issued, and the long-term consequences that can result from a writ being issued. And negotiated settlements are a way to prevent that from happening. A lot of the times, like say we want to come to an agreement for somebody to move within 2 weeks. They get 2 weeks. If they're able to move in those 2 weeks, the case will be dismissed without an eviction judgment. But if they're not able to move, then a writ can automatically be issued. But it resolves a lot of tenants' concerns of just not having enough time after that 3-day notice and then a very prompt eviction filing, just not having enough time to make that move. We've seen landlords benefit from these resolutions too. So settlements, they provide a faster and less expensive outcome than just continued litigation and taking it to a hearing. That helps address their possession concerns and their financial concerns. Judges and courtroom staff benefit from settlements as well. So with Pulaski County handling about half of the eviction filings in Arkansas, well, the greater Little Rock area handling about half. Eviction hearings can put a significant burden on judicial resources in this area of the state. And so when these cases are resolved through settlements that benefit both parties, courts can reserve their time for hearings for disputes that genuinely require actual judicial intervention. And this is a quote that was given to me by Judge Connors, who has been helping us, well, letting us run these eviction courts in her courtroom. And what she has provided us in this quote says, in unlawful detainer cases, the stakes are rarely symmetrical. Yes, the landlord is deprived of financial gain, yet a tenant risks a home. And when both parties understand the law and the process, the court can do what it's meant to do, reach a just result efficiently on the merits rather than on who could better navigate the paperwork. The eviction court program with Legal Aid of Arkansas doesn't tip the scales. They make sure the scales are actually measuring something. And courtrooms work best when every party in it understands what's being asked of them and what's required to prove it. And that's not an advantage for one side. It's the foundation the whole process depends on. I want to talk a little bit about a few of the positive tenant outcomes that we've had as well. Give me one second. Yes, so, and you can read these quotes, but I'll summarize why they're important. The first situation, we had a tenant who was a single mother with children being evicted for housekeeping issues. The writ of possession was denied, but somewhere in the middle, we had a case manager with us on that day. She was experiencing significant emotional distress, and we were able to have a case manager who's trained in de-escalation techniques to help her navigate that hearing before it happened, and then help her navigate the emotional effects after it happened. The writ was ultimately denied, but the situation was traumatic for her, but made better by the presence of a case manager. And then she wouldn't have been represented had we not been holding these eviction courts. In the second situation, this is a negotiated settlement situation where the tenant did pay their rent. They sent it in, and it still proceeded to an eviction hearing, which is accepted in Arkansas. Like even if somebody tries to pay their rent after the eviction is filed, the landlord doesn't have to take it. But we ended up pausing the hearing on that and coming up with an agreement that if her last payment that she had just made cleared and she pays next month's rent on time, then she can stay. That's a tenant who got to stay. And these next two cases, it's important to know that when, and I described this a little bit earlier, when somebody is evicted and they have a Section 8 voucher or they're in public housing, that often leads to the termination of their voucher. And they can no longer stay in a subsidized housing. These are a couple cases where we were able to prevent that from happening. So in this third case, we made an agreement, and the tenant was able to vacate. She vacated. she wanted to maintain her voucher, but the housing authority noted that there was an eviction filed on her record. Um, we were able to contact the housing authority and let them know that there was no eviction judgment, even though the eviction was filed. And so this tenant was able to maintain her housing voucher. It was canceled and then it was reinstated because of that, because there was no judgment and we avoided it with an agreed order. And then this last one, this was a habitability issue where the landlord said the tenant caused the damage. The tenant disputed causing the damage and stated it was a habitability issue. That writ of possession was denied. Landlord didn't meet the burden of proof. And ultimately, what the tenant wanted to do was probably move to other he was wanting to move to other housing because of habitability issues anyway. And so he got 3 additional months, and then he received just a lease non-renewal at the end. He still had his voucher because the writ was denied. There was no eviction, and he was able to transition over to safer housing without the habitability issues. So these are all eviction court cases where we took individuals on as clients last minute, represented them during their possession hearings, and had very good outcomes. And this is what we see consistently whenever we take, these eviction court cases. Just very, very good outcomes. A lot of them tied to negotiated settlements, but a lot of tenants able to preserve their housing or move into other housing without as much difficulty. Okay, so what we want to do after this pilot, we want to find ways to expand these sorts of programs statewide. Much of our work's focused on Pulaski County. I'm in Pulaski County, but the need for eviction defense isn't limited to urban areas. There are many rural and underserved communities, they don't have access or have very little access to legal assistance. And so we want to make sure to cover other areas too, even though the bulk of evictions aren't happening in rural areas. There's still a need in those areas. So we launched another pilot. It was in Greene County. We've held 3 eviction court / pro se assistance days. And our goal was to understand the need of these counties and any challenges that we would face if we wanted to provide these services in a rural community. And the biggest thing we learned is that even though Greene County has fewer evictions filed than more populated counties, the need for representation is still significant. Tenants face the same consequences there when they lose their housing, and then there are even fewer resources available to help them navigate the legal process in rural areas, even fewer than exist in Little Rock. So Little Rock, though our shelters are full, though our rental assistance is limited, there are more community organizations here, and there's turnover at the shelters, and sometimes people can get in, and sometimes there are openings, and sometimes there's rental assistance available. We don't see as much of that in rural counties. We see a more of a lack of the existence of these resources, and the lack of shelter space and places to go. And then, of course, there's difficulties with transportation in rural areas that can complicate even being able to go to your eviction hearing. Many rural issues that these kinds of eviction courts could help address. And then another issue, there's a shortage of attorneys in rural counties. Just fewer lawyers available to help represent tenants makes it difficult to connect people with legal assistance if they need it. And then as we look forward into how to handle eviction courts in rural communities, it's become more clear that to make the program successful long-term, we'll need stronger partnerships with the private bar. So trying to increase pro bono participation from private attorneys. That will be essential if we want to continue to establish these sorts of programs across the state of Arkansas. Legal Aid of Arkansas, we're limited in how many staff attorneys we have. We're limited in resources, and having pro bono attorney involvement could make the difference when it comes to implementation of these kinds of programs. So, want to close out with off inviting everybody who's here right now, if you're interested to get involved. We're trying to make eviction courts a permanent fixture of Pulaski County for sure. And then throughout the rest of the state. We can't do it alone because we need private attorney involvement. So any continued support of courts, courtroom staff, community partners, and then attorneys who can serve pro bono would be crucial to continuing these sorts of programs as we continue to expand them, learn from them, and launch them across the state. So, and just to wrap it up, it's my belief that access to justice shouldn't depend on whether or not you can afford a lawyer. Um, and doing this sort of thing and being able to represent tenants at this sort of rate during an eviction court and have such significant outcomes, it's a very meaningful way to give back to the community. Um, and so if you want to be more involved in the implementation of something like this, feel free to contact me. By the way, with the QR code, all that QR code will do is it's through a certain app. You don't have to download the app. It might invite you to, but it just automatically puts my contact information into your phone. You can put that manually into your phone too. If you have any interest in helping with eviction courts in Arkansas, please reach out to me or Casey Copeland, and we can get you set up. We can start working out a way you can help as we expand these services across the state. And these are my sources. They'll be provided on the slides, which I'm sure everybody will be able to get a copy of these slides. And I want to go ahead. We have like 5 more minutes left. I want to go ahead and open the floor for questions.
Zoya, there was actually one question dropped in the chat that I'll just go ahead and mention here. Are there quality inspections for housing units for folks with subsidized housing?
Yes, there are. So subsidized housing has different habitability standards, federal habitability standards. It has to be habitable. So usually the housing authority will complete an inspection before a tenant can even move into, say, a complex with a private landlord who accepts a Section 8 voucher. Public housing has housing quality standards requirements. Project-based voucher housing does too. It's there are significantly more protections in subsidized housing, and that extends to, habitability requirements. So yes.
Perfect. I think Casey has a few remarks for us.
Yeah, I just first want to just thank everyone for being with us today, and hopefully that hopefully everyone has learned something about eviction courts, and a few of you, if not all of you, are excited about this opportunity for folks in Arkansas, and we'll take Zoya up on her invitation to come and join us, if nothing else, just to see how one of them operates and see how they work, and then maybe get involved here and there as you can. But we also want to kind of talk about some other opportunities that we have here at Legal Aid. Just a few pro bono opportunities at Legal Aid, not a whole lot. It's not going to take very long. Of course, I am the pro bono director. Haley Ortega, who's been moderating today, is one of our pro bono coordinators. We have a number of opportunities. Not only do we have the eviction courts and some other programs, but we have cases that we try to find attorneys for, pro bono attorneys for. And right now we have about 28 to 30 cases, and they range from bankruptcies to Social Security cases and guardianships. And you can kind of see there what we have kind of waiting on deck to find an attorney. So if you're interested in any of these or learning something about some of these cases, maybe taking one on, or at least, if you take on a case from us, that doesn't necessarily mean you're taking it from beginning to end. You could just provide advice and help direct that client in the right direction. So if you have any interest in these, let us know. Of course, volunteering with Legal Aid, there are some supports that we have available, including you're covered by our malpractice coverage for any case that you take from us. We can help pay some out-of-pocket expenses like some filing fees, some service of process fees. There's some mileage reimbursement if you travel, and you can see the rest there. really what we try to do here is just offer ourselves as an extension of your office. And if you need help with any of these things or getting documents signed and notarized or filed, you can always rely on us to help get that done. We also have opportunities at legal clinics, including, we've got one, had one just yesterday in Cabot and got some more coming up. This isn't a complete list. We're always adding clinics to our calendar, and you can watch our events calendar on our main website. But these are opportunities just to come in one day, do a little bit of legal advice, maybe some document drafting, some pro se documents, some estate planning, record sealing, whatever we're doing, and help out on those days and kind of just be done. If you've got a day to take from work, want to come help, we'd be glad to have you come and help. If you do come to a clinic, we just, holler at us. We'll talk about these things. It's great if you've got a laptop. If not, we can set you up. We've got forms, we've got templates. We'll have legal aid attorneys there that know the subject matter. So don't feel like you're just coming and walking into a situation cold. We've got a lot of supports for you, even at those clinics. Also, next Friday, we are also doing another CLE on fair housing issues. Kendall Llewellyn, who's also in our Little Rock office, will be talking about our fair housing project and some opportunities that she has there. So if you've not registered for that, please do so. We'll send this out when we send out your CLE forms at the end of today too. Again, Legal Aid of Arkansas is very appreciative to all of our volunteers and the folks who help us out and help us expand access to justice to those low-income Arkansans who just can't afford attorneys, and especially those like Zoe was talking about in rural areas that, even if, a lot of those folks, even if they can afford an attorney, there's just not a lot of attorneys there or willing to go there. And so those are kind of the things that we're trying to focus on at Legal Aid. And we cannot, like Zoe said, we can't do it without volunteers and people like you. And so we really appreciate you. And if you have questions, reach out. And we will do our best to answer them and get you involved. So thank you. Haley?
Thank you, Casey, and huge shout out here for joining us today, and those of you who consistently just help us with cases throughout the years. Just as a reminder, we will get that certificate of attendance and evaluation form out to you here pretty soon. And that concludes today's program. So thank you so much for joining us. We encourage you to stay connected with us on behalf of our team. Thank you so much for joining us. We appreciate your time and have a great day.